This is your update on Amendment 3 and legal marijuana and medical marijuana. Objectives for this presentation: we're going to review and list the changes to the Missouri medical marijuana program because there are several changes that happened once Amendment 3 passed. List certain definitions that are relevant to law enforcement that have changed. Review purchase and possession rights for not only medical marijuana patients but recreational marijuana users. List limitations of recreational marijuana. So what's the purpose? There are really two sections to Amendment 3, the first dealing with Missouri medical marijuana and the second dealing with recreational marijuana. The purpose is intended to permit state licensed physicians and nurse practitioners to recommend marijuana for medical purposes to patients with serious illnesses and medical conditions. You see, I've highlighted nurse practitioners here, which is going to be a common theme. Anything that I've highlighted in red, I believe are important or are changes from the original medical marijuana amendment. Missouri medical marijuana notable definition changes. A medical marijuana cultivation facility means a facility licensed by the department to acquire, cultivate, process, package, store on or off-site, transport and sell marijuana, marijuana seeds, and marijuana vegetative cuttings, also known as clones. Also going towards the end of the definition, you see that a medical marijuana cultivation facility's authority to process marijuana shall include the production and sale of pre-rolls, but shall not include the manufacture of marijuana-infused products. So before, medical marijuana cultivation facilities were not allowed to manufacture anything. However, now they can manufacture pre-rolls. So what is a pre-roll? A pre-roll is typically marijuana flower rolled in some sort of paper that may or may not have a filter on it. This is commonly referred to as a joint. So now medical marijuana cultivation facilities and medical marijuana dispensary facilities can actually pre-roll these at their site and sell them. Medical marijuana dispensary facility, you can see that they can now process, package, store on or off-site, sell, transport to or from, and deliver marijuana, marijuana seeds, marijuana vegetable cuttings, also known as clones, marijuana-infused products, and drug paraphernalia used to administer marijuana as provided in this section to a qualifying patient, primary caregiver, anywhere on the property or as directed by the qualifying patient. Towards the end of the definition, you see that I've highlighted some stuff in red and underlined it. This is a complete new part of this definition. Dispensary facilities may receive transaction orders at the dispensary in person, by phone, or via internet, including from a third party. So now qualified patients or primary caregivers will be able to order marijuana online or via phone. Medical use means the production, possession, delivery, distribution, transportation, or administration of marijuana or a marijuana-infused product or drug paraphernalia used to administer marijuana or a marijuana-infused product for the benefit of a qualifying patient. Now, this can be used by a qualifying patient or they can be assisted by a primary caregiver. A nurse practitioner, which has now been added to Amendment 3, before it was just a physician, but now a nurse practitioner can actually issue physician certifications just like a regular physician. So a nurse practitioner means an individual who is licensed and in good standing as an advanced registered nurse or successor designation under Missouri law. So a physician certification, what is it? Commonly, this is referred to as a prescription. However, there's no such thing currently as a prescription for marijuana due to its current scheduling on the federal level. So these are called physician certifications in Missouri. A physician and a nurse practitioner can write these now. They can either be handwritten, in electronic form, or any other commonly used format as long as they're signed by a physician or nurse practitioner saying that the qualifying patient has one of the qualifying medical conditions and that marijuana may benefit them. Qualifying patient. Now, the word Missouri resident has been removed from this definition. So, a qualifying patient is an individual diagnosed with at least one qualifying medical condition. So now, not only will Missouri residents be able to be qualified patients and purchase and possess marijuana, any other state that has a medical marijuana program, when they come here with a card, will also be able to purchase and possess marijuana. Missouri medical marijuana cards. Residents can apply for and obtain a Missouri qualified patient card for a fee of $25 and their physician certification. The cards are now good for 3 years and may be renewed with a new physician or nurse practitioner certification. So the time has increased from 1 year to 3 years as far as how long these cards are valid, and the fees have decreased to $25 per card. Upon receiving an application for a qualifying patient, the department has 30 days to either issue a qualifying patient card or deny in writing the qualifying patient card and give a reason for the denial. If the department does not either issue or deny the card within 30 days, then the physician or nurse practitioner certification shall serve as their qualifying patient identification card for up to 1 year of the date on the physician certification. This has actually clarified some of the questions that I got on the original Missouri Medical Marijuana Amendment. How long are nurse practitioner or physician certifications good for? So all applications to the department shall be accompanied by a physician or nurse practitioner certification that is less than 30 days old. So they have 30 days once they get the certification to send that to Department of Health. This is an example of a physician certification. This is not the updated form as it has not been released by Department of Health yet. So if you look at the document on the left side of your screen, towards the top in all bold, it says physician certification. Most likely, they will just change that from physician certification to also nurse practitioner certification. If you look on the right document, about 3/4 of the way down your screen, you see the date of April 7, 2021. That's when the physician signed off on this certification, and the patient has 30 days from that date to send it to Department of Health. A physician or nurse practitioner shall not issue a certification for medical use of marijuana for a non-emancipated qualifying patient under the age of 18 without the written consent of a qualifying patient's parent or legal guardian. The department shall not issue a qualifying patient identification card on behalf of a non-emancipated qualifying patient under the age of 18 without the written consent of a qualifying patient's parent or legal guardian. That card shall be issued to one of the parents or guardians and not directly to the patient. Only a parent or guardian may serve as a primary caregiver for a non-emancipated qualifying patient under the age of 18. Only the qualifying patient's parents or guardian shall purchase or possess medical marijuana for a non-emancipated qualifying patient under the age of 18. A parent or guardian shall supervise the administration of medical marijuana to a non-emancipated qualifying patient under the age of 18. Persons may also apply for and receive what's called primary caregiver cards, which allows them to purchase, possess, and possibly cultivate medical marijuana on a qualifying patient's behalf. These cards are valid for 3 years, which is an increase from 1 year. Primary caregivers may only be caregivers for no more than 6 qualifying patients, which is going to be important later on when we start talking about purchase and possession limits. No primary caregiver cultivating marijuana for more than 1 qualifying patient may exceed a total of 24 flowering plants. So kind of remember that definition, and we'll talk about how they may possibly be able to cultivate up to 24 flowering plants. Missouri medical marijuana purchase limits. The Department of Health may set a limit on how much medical marijuana may be purchased in a 30-day period, so long as it is not less than 6 ounces of dried unprocessed marijuana or its equivalent. So that is an increase from 4 ounces to 6 ounces with the new amendment. Going to our little conversion chart here, we know that 1 ounce of marijuana is equal to 8 grams of marijuana concentrate, and 1 ounce of marijuana is also equal to 800 milligrams of infused product. So if they are allowed to purchase 6 ounces of marijuana in a 30-day period, that means they can purchase 48 grams of marijuana concentrate or 4,800 milligrams of infused product. So if we have a single medical marijuana qualifying patient, they may purchase 6 ounces of dried unprocessed marijuana, 48 grams of concentration, or 4,800 milligrams of THC infused product, or any combination thereof. So going back to the definition of a primary caregiver, remember that a primary caregiver can have up to 6 qualified patients under their care. So if a primary caregiver is also a qualified patient, that means they can purchase 6 ounces of dried unprocessed marijuana for themselves and 6 ounces of dried unprocessed marijuana for each qualified patient under their care. So it's possible that a single primary caregiver who is also a qualified patient and has 6 qualified patients under their care purchases up to 42 ounces of dried unprocessed marijuana or its equivalent in a 30-day period. keeping in mind that these limitations may be increased by either a physician or a nurse practitioner as long as they give compelling reasons why the qualifying patient needs a greater amount. Missouri medical marijuana possession limits. The department may set a limit on the amount of marijuana that's possessed on behalf of each qualifying patient or by each qualifying patient, as long as it's not less than a 60-day supply of dried unprocessed marijuana or its equivalent. So going back to our conversion chart here, if a 30-day supply is 6 ounces, then a 60-day supply is 12 ounces. So 12 ounces of dried unprocessed marijuana is equal to 96 grams of marijuana concentration, or 9,600 milligrams of THC-infused product. So a single qualifying patient may possess 12 ounces of dried unprocessed marijuana, 96 grams of THC concentration, or 9,600 milligrams of THC-infused product, or any combination thereof. So returning to the possession limits definition, we see that a primary caregiver may possess a separate legal amount for each qualifying patient under their care and a separate legal limit for themselves if they are a qualifying patient. So if we have a primary caregiver who is also a qualified patient, and that primary caregiver takes care of 6 additional qualifying patients, that means the primary caregiver can possess 12 ounces of dried unprocessed marijuana for themselves and 12 ounces of dried unprocessed marijuana for each patient under their care. So potentially you could have a primary caregiver possessing up to 84 ounces of dried unprocessed marijuana or its equivalent in a 60-day period. Missouri medical marijuana qualified patient cultivation. Qualifying patients may cultivate marijuana for medical use and possess up to a 90-day supply so long as that supply remains on property under their control. So they must apply for and receive a qualifying patient cultivation card from the Department of Health. So a single qualified patient cultivator may possess 18 ounces of dried unprocessed marijuana, 144 grams of THC concentration, or 14,400 milligrams of THC-infused product. So how much marijuana are they allowed to grow? A single qualifying patient cultivator may cultivate up to 6 flowering marijuana plants, 6 non-flowering marijuana plants over 14 inches tall, and 6 marijuana clones or marijuana plants that are non-flowering less than 14 inches in height. The medical marijuana cultivation card will be valid for 3 years. So if we have a single patient cultivator, they can cultivate 6 clones under 14 inches tall and non-flowering, 6 non-flowering marijuana plants in excess of 14 inches, and 6 flowering marijuana plants for a total of 18 plants. All qualifying patient cultivation shall take place in an enclosed lock facility that's equipped with security devices that only permits access to the qualifying patient or that qualifying patient's primary caregiver. Now, keeping in mind, reading further into this, we see that 2 qualifying patients who both hold qualifying patient cultivation cards may share one enclosed lock facility. So if we have 2 patient cultivators who decide to share a single enclosed lock facility, they may cultivate 12 clones which are non-flowering below 14 inches in height, 12 non-flowering plants that are in excess of 14 inches, and 12 flowering marijuana plants. Now, keep in mind, going back to the primary caregiver definition, we know that a primary caregiver may have up to 6 qualifying patients under their care. And we read further into that definition where it says no primary caregiver cultivating marijuana for more than one qualifying patient may exceed a total of 24 flowering plants. So if we continue on the Missouri medical marijuana cultivation definition, we see that primary caregivers cultivating marijuana for more than one qualifying patient may cultivate each respective qualifying patient's flowering plants in a single enclosed lock facility. So if we have a primary caregiver who's growing on the behalf of 3 qualifying patients, it's possible they have 18 clones, 18 non-flowering plants, and 18 flowering marijuana plants all in a single enclosed lock facility. A primary caregiver shall not be subject to criminal or civil liability or sanctions under Missouri law for purchasing, transporting, or administering marijuana for medical use to a qualifying patient, or participating in the patient cultivation of up to 6 flowering marijuana plants, 6 non-flowering marijuana plants, and 6 clones per patient, and no more than 24 flowering plants for more than one qualifying patient. Remember, primary caregivers may have up to 6 patients under their care. If a single primary caregiver has 6 patients under their care, and those 6 patients are also qualified patient cultivators, then that primary caregiver may cultivate marijuana on their behalf. The primary caregiver cultivator may cultivate up to 36 clones, 36 non-flowering plants, but may only cultivate a total of 24 flowering plants. This limit does not apply if the primary caregiver cultivator is also a qualified patient cultivator, which then they would be allowed to cultivate their own amount of medical marijuana. Missouri medical marijuana and law enforcement. Possession of between the legal limit and up to twice the legal limit shall only subject the possessor to department sanctions, including an administrative penalty of up to $200 and the loss of their patient identification card up to a year. Purposely possessing amounts in excess of twice the legal limit shall be an infraction under applicable law. So if they possess more medical marijuana than they're supposed to, as long as it does not exceed twice their legal limit, only department sanctions will be taken. If they purposely possess marijuana in excess of twice the legal limit, then officers may write an infraction. So what is an infraction? Looking under RSMO 556.020, an infraction does not constitute a criminal offense, and conviction of an infraction shall not give rise to any disability or legal disadvantage based on conviction of a criminal offense. Except as otherwise provided by law, the procedure for infractions shall be the same as for a misdemeanor. So essentially, you would just be writing them a ticket. Now, the question is, what will that citation be for? That I don't know the answer to yet. So what about selling marijuana? A lot of times I get the question is, can Missouri medical marijuana patients cultivate their own marijuana and sell it to each other? The answer is no. Except otherwise provided in this article, all marijuana for medical use sold in Missouri shall be cultivated in a licensed medical marijuana cultivation facility that's also located in Missouri. Nothing in this section shall provide immunity for operating a vehicle, aircraft, dangerous device, or navigating a boat under the influence of marijuana. What about search warrants? This is where we get a lot of additional information from Amendment 3. In the process of requesting a search warrant or arrest warrant relating to the production, possession, transportation, or storage of marijuana, law enforcement shall verify with the department whether the targeted person is a qualifying patient or primary caregiver holding an identification card for the cultivation of marijuana plants. And they shall inform the issuing authority accordingly when making a warrant request. So if you are requesting a search warrant from the prosecutor, you are required to look up to see if that person has a medical marijuana card. And if so, even if not, you're supposed to provide that information to the prosecutor and to the judge. Now, a lot of times I get questions of, can we access this information for other reasons? The answer is no. Law enforcement shall only have access to such department information as is necessary to confirm whether the targeted person holds a registration card. Evidence of marijuana alone without specific evidence indicating that the marijuana is outside of what is lawful for medical or adult use cannot be the basis for a search of a patient or non-patient, including their home, vehicle, or other property. So if you have somebody that is possessing marijuana and that's all that you have, that is not probable cause to search their car, their home, or other property unless you have additional information that that marijuana is illegal. Law enforcement can fill out complaint forms, which would allow the Department of Health to take administrative actions. Those complaint forms are available using this QR code. So if you pull out your cell phone camera and point it at this QR code, that will direct you to the Department of Health and Senior Services complaint forms page. So you have access to all of the complaint forms. As far as citations, I would suggest that you talk to your local prosecutor, and administration on what they're wanting you to write for these infractions. Lawful marijuana-related activities cannot be the basis for a violation of parole, probation, or any type of supervised release. So that does clarify some of the original information or the gray areas of the original Missouri Medical Marijuana Amendment. Continuing on with parole and probation. Qualifying patients on bond for pretrial release, on probation, or other forms of supervised release shall not be prohibited from legally using a lawful marijuana product as a term or condition of release, probation, or parole. An alternative sentencing drug court program may not prohibit individuals under its jurisdiction from using a lawful marijuana product. So this was also a question under the original Missouri Medical Marijuana Amendment was, can people on parole or probation use marijuana? Under Amendment 3, the answer is they shall not be prohibited from using it legally. Here's another question that I got a lot. If you have a Missouri Medical Marijuana qualifying patient card, does that prohibit you from possessing a firearm? In Missouri, the answer is no. If you read Amendment 3, no person shall be denied their rights under Article 1, Section 23 of the Missouri Constitution. Well, what is Article 1, Section 23 of the Missouri Constitution? It is the right to keep and bear arms, ammunition, and certain accessories. So if you have a Missouri Medical Marijuana card, under Missouri law, you are able to legally possess a firearm, ammunition, and certain accessories. Missouri Medical Marijuana limitations. Nothing in this section permits a person to consume marijuana for medical use in a jail or correctional facility. A person who smokes marijuana in public, other than in an area licensed for such activity by the department or by local authorities having jurisdiction over licensing, is subject to a civil penalty not exceeding $100. So this is not a crime in itself, it's only a civil penalty. Nothing in this section permits a person to undertake any task under the influence of marijuana when doing so would constitute negligence or professional malpractice. And this does not permit them to operate, navigate, or be in actual physical control of any dangerous device or motor vehicle, aircraft, or motorboat while under the influence of marijuana. So when we're talking about DWI and operating a vehicle while under the influence of marijuana, the amendment goes a little bit further. It says that the crime shall require evidence that the person was in fact under the influence of marijuana at the time the person was in actual physical control of the dangerous device or motor vehicle. The mere presence of marijuana, THC, or its metabolites, or any combination thereof, is not enough to be guilty of DWI or possessing a dangerous device. So really, if you look at this, it doesn't actually change any way that we would investigate a driving while intoxicated offense when it comes to marijuana intoxication. It never was okay to simply arrest somebody for driving while intoxicated drugs just because they have used any sort of drug. So the officer should investigate the driving while intoxicated case thoroughly and document any evidence of impairment. The possession of marijuana in quantities less than the limits of this section and transportation of marijuana by the qualifying patient or primary caregiver shall not subject the possessor to arrest so long as they produce on demand a qualifying patient identification card, a valid qualifying patient cultivation identification card, or a valid physician or nurse practitioner certification while making application for an identification card. So if they possess a valid physician or nurse practitioner certification, they are allowed to possess and transport marijuana while making application. So they would have 30 days to use that physician certification or nurse practitioner certification as their identification card. Or if they produce on demand a valid primary caregiver identification card. So what about medical marijuana cards from another state? Production of a respective substantially equivalent identification card or authorization issued by another state or political subdivision of another state shall also meet the requirements of this subdivision. So that means if somebody comes here from another state and has a medical marijuana card from another state, then they shall not be subject to arrest or any civil or criminal penalties. Missouri medical marijuana and a little bit of extra information. Missouri medical marijuana packaging. No medical marijuana cultivation facility, dispensary facility, or medical marijuana infused product manufacturing facility shall manufacture, package, or label marijuana or marijuana infused products in a false or misleading manner. No person shall sell any product in a manner designed to cause confusion between a marijuana or marijuana infused product and any product not containing marijuana. All marijuana infused products for medical use sold in the state of Missouri shall be manufactured in a medical marijuana infused product manufacturing facility. So, a qualifying patient may not create a medical marijuana infused product and then sell it. So, what about Missouri medical marijuana employees and employers? Unless a failure to do so would cause an employer to lose a monetary or licensing related benefit under federal law, an employer may not discriminate against a person in hiring, termination, or any term or condition of employment, or otherwise penalize a person if the discrimination is based upon either of the following. First, the person's status as a qualifying patient or primary caregiver who has a valid identification card, including the person's legal use of lawful marijuana product off the employer's premises during non-working hours, unless the person was under the influence of medical marijuana on the premises of the place of employment or during the hours of employment. Or a positive drug test for marijuana components or metabolites of a person who has a valid qualifying patient identification card, unless the person used, possessed, or was under the influence of medical marijuana on the premises of the place of employment or during the hours of employment. Now, moving on to Missouri recreational marijuana. The purpose of this section is to make marijuana legal under state and local law for adults 21 years of age or older. This section is not intended to allow for the public use of marijuana, driving while under the influence of marijuana, the use of marijuana in the workplace, or the use of marijuana by persons under 21 years of age. Looking at definitions, marijuana means cannabis indica, cannabis sativa, and cannabis ruderalis, hybrids of such species, and any other strains commonly understood within the scientific community to contain marijuana, and this is in addition to the medical marijuana definition, as well as resin extracted from the marijuana plant and marijuana infused products. Marijuana does not include industrial hemp as defined by Missouri statute or commodities or products manufactured from industrial hemp. Marijuana accessories means any equipment, product, materials, or combination of equipment products or materials which is specifically designed for use in planting, propagating, cultivating, growing, harvesting, manufacturing, compounding, converting, producing, processing, preparing, testing, analyzing, packaging, repackaging, storing, ingesting, inhaling, or otherwise introducing marijuana into the body. In the past, we probably would have referred to these devices as drug paraphernalia. However, under this definition, it will be marijuana accessories. Comprehensive marijuana dispensary facility. A comprehensive marijuana dispensary facility is a dispensary facility that will allow qualified patients, primary caregivers, or what we call consumers, which is a recreational marijuana user, to purchase marijuana products from. A micro-business dispensary facility means a facility licensed by the department to acquire, process, package, store, on-site or off-site, sell, transport to or from, and deliver marijuana seeds, marijuana vegetative cuttings, marijuana-infused products, and drug paraphernalia used to administer marijuana to consumer, qualifying patient, or primary caregiver anywhere on the licensed property or to any address as directed by the consumer, qualifying patient, or primary caregiver, and consist with the limitations of this article. I'm really not quite sure what this business looks like. It looks very close to the definition of a medical marijuana dispensary facility. So I'm not sure if this is a standalone business or maybe this is a business that can add an addition to their business and call it a micro business dispensary. I'll still be looking for some clarification on this definition. What is an infused pre-roll? We saw with the Missouri Medical Marijuana Program that they've introduced the definition of pre-roll, but the recreational program introduces the definition of infused pre-roll, which is a consumable or smokable marijuana product generally consisting of wrapper paper, dried flower buds or plant material, and a concentrate, oil, or other type of marijuana extract either within or on the surface of the product. Infused pre-rolls may not include a filter or crutch at the base of the product. So what you might actually see are pre-rolls that are coated with some sort of white crystal, which is called THCA, or they may actually infuse the marijuana with some sort of marijuana extract, making it have higher THC concentrations. Recreational limitations. Except as otherwise provided in this article, this section does not preclude, limit, or affect laws that assign liability relative to, prohibit, or otherwise regulate delivery or distribution of marijuana or marijuana accessories with or without consideration to a person younger than 21 years of age, purchase, possession, use, or transport of marijuana accessories with or without consideration to a person younger than 21 years of age, consumption of marijuana by a person younger than 21 years of age, or possession or consumption of marijuana or possession of marijuana accessories on the grounds of a public or private preschool, elementary, or secondary school, institution of higher education, in a school bus, or on the grounds of any correctional facility. So this does not allow you to do these things. It does not allow you to operate or be in physical control of any motor vehicle, train, aircraft, motorboat, or other motorized forms of transport while under the influence of marijuana. Keeping in mind, just like under the Missouri medical marijuana section, it is not enough to simply test positive for THC or THC metabolites. It shall require evidence that the person was in fact under the influence of marijuana at the time the person was in physical control of the motorized form of transport. So once again, this should not change any way that we investigate or arrest somebody for driving under the influence of any sort of drug. It does not allow for the consumption of marijuana while operating or being in physical control of a motor vehicle, train, aircraft, motorboat, or other motorized form of transport while it is being operated. So this is another area where it's actually clarified some things. I've received a lot of questions on, can people smoke marijuana and drive down the road? Is that illegal in itself? This recreational amendment does not allow them to do that. It does not allow for smoking marijuana within a motor vehicle, train, aircraft, motorboat, or other motorized form of transportation while it is being operated. It does not allow for smoking marijuana in a location where tobacco is prohibited. Or it does not allow for the consumption of marijuana in a public place other than in an area licensed by the authorities having jurisdiction over the licensing and or permitting of said activity. So certain jurisdictions may allow for the consumption of marijuana in a public place. So that would be like your local governments. It does not allow any conduct that endangers others. It does not allow undertaking any task while under the influence of marijuana, if doing so would constitute negligence, recklessness, or professional malpractice. It does not allow for performing solvent-based extractions on marijuana using solvents other than water, glycerin, propylene, glycol, vegetable oil, or food-grade ethanol unless licensed for the activity by the department. So people will not be allowed to extract THC from marijuana using basically combustible solvents such as butane. Purchases. Neither the department or any governmental body may restrict the production or use of marijuana and marijuana-infused products based solely on THC content. So basically, these products are allowed to have as much or as little THC in them as the manufacturer would like. So the department can set a limit on the amount of marijuana that may be purchased in a single transaction, provided that that limit is not less than 3 ounces of dried unprocessed marijuana or its equivalent. I really don't know what a single transaction is. Can I purchase 3 ounces of dried unprocessed marijuana now and then purchase 3 more ounces of dried unprocessed marijuana the same day? But the amendment does read per single transaction. The department may not promulgate a rule that requires a consumer to provide a marijuana facility with identifying information other than identification to determine the consumer's age. So basically, recreational marijuana users will not be required to get any sort of card, but they will be required to provide some sort of identification to prove they are 21 years of age or older when purchasing the marijuana. All marijuana sold in Missouri pursuant to this section shall be cultivated in Missouri, and all marijuana-infused products sold in Missouri pursuant to this section shall be manufactured in Missouri. Packaging requirements. No marijuana facility shall manufacture, package, or label marijuana or marijuana infused products in a false or misleading manner. I know that on the road we see all types of packaging. We've seen things that maybe mimic Doritos or some sort of gummy bears. According to the Missouri Constitution, they are not allowed to do that. No person shall sell any product in a manner designed to cause confusion between marijuana or marijuana infused products and any product not containing marijuana. A violation of this subdivision shall be punishable by an appropriate and proportional department sanction. So it's not necessarily a crime, it would be something that the Department of Health would sanction that business for. No marijuana facility may sell edible marijuana infused candy in shapes or packages that are attractive to children or that are easily confused with commercially sold candy that does not contain marijuana. All marijuana and marijuana infused products shall be sold in individual, child resistant containers that are labeled with serving amounts, instructions for use, and estimated length of effectiveness. All marijuana and marijuana infused products shall be sold in containers clearly and conspicuously labeled as mandated by the department as containing marijuana or a marijuana infused product. Cultivation. Within 30 days of December 8th, the department shall make available to the public application forms and application instructions for personal cultivation. Within 60 days of December 8th, 2022, the department shall begin accepting applications for such registration cards. The card shall be valid for 12 months from its date of issuance and shall be renewable. The department shall charge an annual fee for the card of $100. So this would be personal recreational cultivation. They are still required to obtain a card from the Department of Health. Except for good cause, a person at least 21 years of age or older may obtain a registration card from the department to cultivate up to 6 flowering marijuana plants, 6 non-flowering marijuana plants in excess of 14 inches, and 6 clones that are under 14 inches tall for non-commercial use. The plants and any marijuana produced by the plants in excess of 3 ounces are kept at one private residence, are in a locked space, and are not visible by the normal unaided eye from a public place. So they are allowed to possess more than the 3 ounces if they meet these conditions. Not more than 12 flowering marijuana plants are kept in or on the grounds of a private residence at one time. So we're assuming that if 2 individuals have cultivation cards, that they will be allowed to grow their marijuana together, but it cannot exceed 12 flowering plants. Recreational marijuana and law enforcement. The following acts by a person at least 21 years of age or older are not unlawful: purchasing, possessing, consuming, using, ingesting, inhaling, processing, transporting, delivering without consideration, or distributive without consideration 3 ounces or less of dried unprocessed marijuana or its equivalent. So they are allowed to possess, purchase, consume, use, transport up to 3 ounces or less of dried unprocessed marijuana. It is not unlawful possessing, transporting, planting, cultivating, harvesting, drying, processing, or manufacturing up to 6 flowering marijuana plants, 6 non-flowering marijuana plants, and 6 clones, provided that the person is registered with the department for the cultivation of marijuana. It is not unlawful if the plants and any marijuana produced by the plants in excess of 3 ounces are kept at one private residence and are in a locked space. Assisting another person who is at least 21 years of age or older in or allowing the property to be used for any of the acts permitted by this section in purchasing, possessing, using, delivering, distributing, manufacturing, transferring, or selling to the person 21 years of age or older. So that is not illegal. It is not unlawful to purchase, possess, use, deliver, distribute, manufacture, transfer, or sell to any person 21 years of age or older any marijuana accessories. Okay, so what if they violate these rules? Violations. A person who cultivates marijuana plants that are visible by normal, unaided vision from a public place is subject to a civil penalty not exceeding $250 and forfeiture of their marijuana. A person who cultivates marijuana plants that are not kept in a locked space is subject to a civil penalty not exceeding $250 and forfeiture of their marijuana. A person who smokes marijuana in a public place other than in an area licensed for such activity by local authorities is subject to a civil penalty not exceeding $100. A person who is younger than 21 years of age, who possesses, uses, ingests, inhales, transports, delivers without consideration, or distributes without consideration 3 ounces or less of marijuana, or possesses, delivers without consideration, or distributes without consideration marijuana accessories, is subject to a civil penalty not to exceed $100 and forfeiture of their marijuana. Any such person shall be provided the option of attending up to 4 hours of drug education or counseling in lieu of the fine. Subject to the limitations of this section, a person who possesses, produces, delivers without receiving any consideration or remuneration, or remuneration to a person who is at least 21 years of age, or possesses with intent to deliver not more than twice the amount of marijuana allowed. A first violation of any of these is subject to a civil infraction punishable by a civil penalty not exceeding $250 and forfeiture of their marijuana. A second violation is subject to a civil infraction punishable by a civil penalty not exceeding $500 and forfeiture of their marijuana. So everything we've talked about thus far is simply a civil issue and not a crime. The third or subsequent violation is subject to a misdemeanor punishable by a fine not exceeding $1,000 and forfeiture of marijuana. So there would be no criminal charges until a third violation of any of the above listed issues. A person 21 years of age is subject to a civil penalty not to exceed $250. They shall be provided the option of attending up to 8 hours of drug education or counseling in lieu of a fine, and in lieu of payment penalties under this subsection may be satisfied by the performance of community service. No conduct permitted by this section shall constitute the basis for detention, search, or arrest, and except when law enforcement is investigating driving a motor vehicle while under the influence of marijuana, the odor of marijuana or burnt marijuana, the possession or suspicion of possession of marijuana, without evidence of a quantity in excess of the lawful amount, or the possession of multiple containers of marijuana without evidence of the quantity in excess of the lawful amount, shall not individually or in combination with each other constitute reasonable, articulable suspicion of a crime. Now let's talk about search warrants. This is where there is some additional information that each law enforcement agency is required to provide at the end of the year if they participate in these activities. Prior to requesting a search warrant or arrest warrant relating to the cultivation of marijuana plants, law enforcement shall verify with the department whether the targeted person holds a registration card allowing for the cultivation of flowering marijuana plants, and shall inform the issuing authority when making the warrant request. Evidence of marijuana alone, without specific evidence indicating that the marijuana is outside of what is lawful for medical or adult use, cannot be the basis for a search of a patient or non-patient, including their home, vehicle, or other property. Each time a law enforcement officer executes a search warrant authorizing entry upon the premises for an alleged marijuana offense, the officer must first knock or announce their presence or purpose prior to entering the premises. Now, after executing a search warrant for an alleged marijuana offense or conducting a warrantless search of an alleged marijuana offense, the officer shall report the following information to the agency that employs the officer. First, the reasons for the warrant, or in case of a warrantless search, a detailed account of either the probable cause or imminent circumstances, if any, which led to the warrantless search. They must also submit the information on whether any marijuana was discovered during the course of the search, whether any marijuana was seized during the search, and if so, the amount seized, whether an arrest was made as a result of the search, and if an arrest was made, the crime that is suspected. Each law enforcement agency shall compile the data described for the calendar year into a report and shall submit that report to the Attorney General no later than March 1st of the following calendar year. So, what are these reports going to look like? The Attorney General shall determine the format that all law enforcement agencies shall use to submit the report. The Attorney General shall submit a summary of the annual reports of law enforcement agencies to the Governor, the General Assembly, and each law enforcement agency no later than June 1st of each year. The summary that the Attorney General shall provide shall include the total number of search warrants executed by each agency in the previous calendar year for alleged marijuana offenses, and a compilation of the information reported by law enforcement agencies pursuant to this paragraph. So, what about gun rights and recreational marijuana? No person shall be denied their rights under Article 1, Section 23 of the Missouri Constitution, which says Missouri citizens have the right to bear arms, ammunition, and certain accessories. So if they are a recreational marijuana user, under Missouri law, they are allowed to possess a firearm. Moving on to parole and probation. Lawful marijuana-related activities cannot be the basis for a violation of parole, probation, or any type of supervised release. State and local law enforcement shall have access to the department information as is necessary to confirm whether the targeted person holds a registration card. What about employees and employers when it comes to recreational marijuana? This section does not limit any privileges, rights, immunities, or defenses of a person or entity or any other law of this state allowing for or regulating marijuana for medical use. This section does not require an employer to permit or accommodate conduct otherwise allowed by this section in any workplace or on the employer's property. It does not prevent an employer from disciplining an employee for working while under the influence of marijuana. It does not prevent an employer from refusing to hire, discharging, disciplining, or otherwise taking an adverse employment action against a person with respect to hire, tenure, terms, conditions, or privileges of employment because that person was working while under the influence of marijuana. There is some information that does give a little bit of local control. A local government may prohibit the operation of all micro businesses dispensary facilities or comprehensive marijuana dispensary facilities, so these are the recreational facilities, regulated under this section from being located within its jurisdiction, either through referral of a ballot question to the voters by the governing body or through citizens' petition, provided that citizen petitions are otherwise generally authorized by the laws of the local government. Local governments may enact ordinances or regulations not in conflict with this section or with regulations enacted pursuant to this section governing the time and place where marijuana may be smoked in public places within the locality, the consumption of marijuana-infused products within designated areas, including preparation of culinary dishes or beverages by local restaurants for on-site consumption on the same day it's prepared. So local governments can allow this. I know that there are still a lot of unanswered questions that we don't really know the answer to yet, but hopefully we'll get some clarification as the amendment begins its rollout and Department of Health comes out with some more rules and regulations. Thanks for your time and stay safe.